Please be seated. We have one case on the docket scheduled for oral argument this morning, the case of the University of Florida Board of Trustees and the Florida Board of Governors versus Lisa Browning et al. Counsel ready to proceed? You may approach, counsel. Counsel, we have allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor, I'd like to reserve 3 minutes.
So noted, Madam Clerk. You may continue, counsel.
Thank you. May it please the court, my name is Jeff Slanker. I'm here with my law partner, Rob Sniffen. I have the pleasure of representing the University of Florida Board of Trustees and the Florida Board of Governors today in this case, which concerns sovereign immunity, a fundamental part of our state's constitutional blueprint. Of course, we know that sovereign immunity can only be waived through the clear and unequivocal enactment of the legislature. We know that sovereign immunity is part of and really animated by the state of Florida's separation of powers doctrine. Circuit Court here was confronted with a number of iterations of a complaint, a class action complaint seeking millions of dollars in damages from the University of Florida and the Florida Board of Governors under a host of causes of action, traditional contract type actions, breach of contract claim, and also a number of tort claims. There's those tort claims that we're here to hear today. There's a declaratory relief claim, a claim for conversion, and a claim for negligent misrepresentation. Now, as we've argued in our papers, Circuit Court got it right in recognizing that the breach of contract claim concerned an implied contract at best, that there was no express written contract upon which a claim against the state can lie. And that's black letter law from Pan Am. Pan Am says there can be breach of contract claims against the state and its agencies, but only when it's premised on an express written contract.
But breach of contract claims are not before us. Is that correct, counsel?
Yes, Your Honor. They aren't. And I say that to lead into our primary point, which is these tort claims, they're not tort claims. They're nominal tort claims. They're tort claims in name only. They really are repackaged implied contract claims. Some of these claims only came about after multiple pleadings of the complaint. I believe we're here on the third amended complaint. So we've got a conversion claim that kind of sounds like a conversion claim, but it's not a conversion claim. We've got a negligent misrepresentation claim that kind of checks all the boxes, or kind of not checks all the boxes, I should say, but has all the buzzwords of being a negligent misrepresentation claim.
In
but it's really an
regards
implied
to your
contract
conversion claim, you argue that the appellants are immune from appellee's conversion claims because a private individual could not be held liable in the same circumstances. I understand appellees argue that this issue was not preserved below for purposes of this appeal. And how do you respond to the preservation issue?
Your Honor, so I would say we have one primary overarching argument as to all of the tort claims, and that is that you can't have under 768, and I think it's fair to say that the parties are operating under the understanding, right, that the waiver of tort statute in 768 is what would effectuate the waiver in this case, if there is one. So our primary argument is that the statute doesn't encompass tort claims solely for economic loss. We are also arguing, and Judge Lewis, to answer your question, on the conversion claim specifically, that a private person would not likely be held or similarly be held liable because the conversion claim concerns money or general indebtedness.
Well, I understand you argue sovereign immunity below, but did you argue this precise issue below?
That precise issue, Your Honor, we did not argue below, and it's nonetheless properly before this court for this reason. The case cited by my friends on the other side for that point was the Manning case of this court, and it's true that this court and the Florida Supreme Court have said that this precise legal issue and the precise legal argument has to be presented below for it to be preserved for appeal. In that case, it also delineates a number of exceptions. One of those exceptions is when the matter speaks to the subject matter jurisdiction of the court. We know, of course, sovereign immunity speaks to the subject matter jurisdiction of the court. number of courts, this court, I believe, has held, and we've cited these in our papers, that sovereign immunity can be raised for the first time on appeal even. So it's hard for me to reconcile, and I don't believe you can reconcile that line of cases with the argument that there was a preservation issue here. The fact of the matter is that Jackson recognized that sovereign immunity is an important part of our state's constitutional blueprint and rewrote the interlocutory appeal rule to give government entities the right to get this issue heard up front. I don't think there's an argument.
Sovereign immunity was raised below.
It was, Your Honor.
Right. So is this a pleading issue or a subject matter jurisdiction issue?
Your Honor, I would say that sovereign immunity was asserted as a defense below, and the denial of the sovereign immunity motion obviously gave us the right under the interlocutory appeal rules to come before you. The fact that we might take some different approaches on that issue that is preserved and that provided us an entry point here, I don't think results in a preservation issue, especially because it, again, speaks to that subject matter jurisdiction, that core defense that can never be waived and can be raised for the first time on appeal. Specifically, sovereign immunity can be raised for the first time on appeal because it's so important, because it's such a part of the separation of powers doctrine, and because of all of the things that the court in Jackson said about how important getting these issues right is. And in this case, again, what we have is a situation where the circuit court really deviated from two other districts, two sister districts, specifically the 5th District and the 4th District. The 5th District, held in the Miorelli case that...
Well, counsel, I mean, your primary point is this is all economic damages. They're not seeking damages, obviously, for bodily injury or for damage to actual property or loss of property in a more chattel sense. If we accepted your argument on the economic damages front, would we have to reach your other arguments about operational versus discretionary function and your argument about, I guess, your alternative argument about conversion?
No, Your Honor. I don't believe that you would, because all of the claims here are sounding in pure economic loss. They're like the claims in Miorelli. They're like the claims in Pembroke Pines, where they're tort claims, but exactly what you said, Judge Tannenbaum, they're not tort claims concerning what 768 specifically waived, which was injury or loss to property, wrongful death, personal injury. So these other issues in terms of the conversion, the negligent misrepresentation claim, as Your Honor said, where we focused on the operational discretionary function, no. I mean, we would submit that if this court were to adopt the holding and the reasoning in Miorelli and in Pembroke Pines, then each of these claims, this declaratory judgment action, this conversion action, this negligent misrepresentation claim, would be barred by sovereign immunity and would be appropriate for a reversal of the circuit court and instructions to dismiss those claims as barred by sovereign immunity.
So do you read 768-28, which, I mean, just to take it back to the statute, which I think that's what this is all about at the end of the day. Do you read 768-28, subsection 1, as focusing on the type of damages being sought in the complaint, regardless of the label put on any of the counts? Like, call it tort, call it contract, whatever you want to call it. Is the question, does the complaint seek the type of damages that 768-28 spells out for the waiver?
Well, I think that the way that I would answer that, Judge Tannenbaum, is I think that 768 talks about, it obviously is a waiver to tort, and I believe there's a number of cases that talk about 768 being a recognition of the torts that were in the common law at the time of the enactment of the statute. What I read it to be is a focus on not necessarily about the type of damages, but the type of harm and the harm suffered.
Well, what's the difference?
Well, so the difference would be, I think that the difference would be I mean, that's a, that's a good point, Judge Tannenbaum, because certain harm only produces certain damages. So that's a fair point. I think what the distinction I'm trying to make is the other side has said, well, it says you can get money damages, and that's all we're asking for. But you can only get money damages for certain types of harm, and this type of harm, very similar to the loss of economic viability in a property, causing money damages in Miorelli, and the issues with the value of the land subject to the development application in the city of Pembroke Pines. It's this pure economic loss type claim, and that's a contract claim. So I don't know how
Counsel,
you...
does the economic loss rule apply to tort claims, specifically conversion claims?
Well, Your Honor, the economic loss rule, of course, was abolished by Tiara, by the Supreme Court. And what we're saying is that, and this is something that Justice Perienti noted in her concurrence, the economic loss rule wasn't so much abolished, but rather basic contract principles were kind of at play. And reaffirmed that the independent tort doctrine is still alive and well in Florida. So we'd submit, frankly, Your Honor, that these tort claims that are brought are completely tied up with the contract claim. They're absolutely not independent torts. But I think that what Judge Tannenbaum just said a question or two ago, this claim is ultimately about the statute, is really important to remember. And I want to make clear that we were providing the background on the independent tort doctrine and the economic loss doctrine as background for why this is a sound holding and a good
The trial court found
interpretation.
that the independent tort doctrine does not apply to this case.
Excuse me, Your Honor?
Did the trial court find that the independent tort doctrine did not apply to the facts of this case?
I don't think that the trial court specifically referenced the independent tort doctrine, but ultimately this is an issue of statutory interpretation. I would say that the Supreme Court's action in Tiara overruling the economic loss doctrine had no impact on this line of cases because that was a
Is it your view
private...
that the Pembroke Pines case applied to the facts of this case?
Excuse me, Your
Is
Honor?
it your view that the Pembroke Pines case applies to the facts of this case?
Yes, Your Honor, and Pembroke Pines and Miorelli looked at the statute. So I don't think that you could say in a state with a constitutional amendment that says only the legislature can waive sovereign immunity through an enactment that is clear and unequivocal and that requires no inference or implication that a Supreme Court ruling on a case involving private parties can have any impact on the interpretation of 768. The Supreme Court couldn't alter that jurisprudence, and that's basic sovereign immunity law. And what we have
Counsel,
here...
you are into your rebuttal time. However, we will extend your argument by an additional 5 minutes, and we'll extend counsel for the appellee's argument by an additional 5 minutes. You may continue.
Well, Your Honor, I think I've made my most salient points here. I did want to say something very briefly about the board, and I appreciate Your Honor's courtesy in letting me speak a little bit past my time.
Before you get to the board,
Sure.
in terms of your declaratory judgment argument, what authority states that sovereign immunity bars the declaratory judgment claims?
Your Honor, it's 768 again, and I don't mean to say this to be flippant, and I know you say that right before maybe you say something flippant, and I don't mean it that way. I don't understand how a declaratory judgment claim that concerns not a live controversy, not a present issue, but seeks very plainly in the complaint to declare rights as to past harms and entitlement to damages related to past harms can never lie. There would be no sovereign immunity in Florida because you could just take your barred claims, call them an action for declaratory relief, regardless of if there's a present right or controversy that's in dispute, and say, well, I've got a declaratory judgment claim, that's not barred. 768 doesn't permit that type of action. I don't think the Declaratory Judgment Act was ever meant to be interpreted this way. The cases cited by my friends on the other side support that interpretation. Those cases all involved present instances of harm and uncertainty as to rights that had to be resolved, and the request was for injunctive relief.
Well, actually, isn't the purpose of the declaratory, and I'm not disagreeing with you, but just to put a finer point on it, isn't the purpose of the Declaratory Judgment Act to allow for causes of action that didn't otherwise exist because there wasn't any damage?
Your Honor, that's correct.
Almost like anticipatory.
Correct, Your Honor.
And when they have to admit that there weren't damages in advance to seek a declaratory judgment action?
Correct, Your Honor. What they've pled is, we want a declaration that we were charged too much, and we want a declaration that we're entitled to monies, recoupment of monies, and somehow that's going to be enforced. That's just not a claim and a formulation of that claim that I can find any legal support for, and I don't think that it properly lies here. I think it would eviscerate sovereign immunity in our state. It really would. It's an end around to Pan Am and to 768 and to the task that courts are bound to find, has there been an action by the legislature that's clear and unequivocal, waiving sovereign immunity?
Counsel, can I take you back just for a second to the 1970s when I think 768, or the original version of 768-28 was adopted? Are you familiar at all with, or do you know what the status of tort law at the time when this was originally, like when we're talking about economic loss rule, or when it was created, or whether there was negligent misrepresentation cause of action existed? And is it possible that the legislature passed the original sovereign immunity waiver with the idea that there was this, it was just a typical type of cause of action for bodily injury and not for economic loss at the time?
Yeah, I think that's certainly supported by the landscape of tort at the time. The evolution of the economic loss rule, as this court no doubt knows, has been ever-changing over the years, and many different cases going back and forth leading to TR. So certainly the landscape at the time that 768 was enacted was that that's not the type of tort that is going to lie. It was fairly automatic, the application of the economic loss rule at the time that 768 was enacted, at least my understanding. I think there were, I believe I did a survey of whether there were cases involving negligent misrepresentation, and I don't remember at the time that 768 was enacted. I don't remember enough to represent to this court whether there were or were not, but I remember there were not many cases at that point. But the point being, and a point taken, Judge Tannenbaum, I think that the landscape certainly at the time and what the legislature was confronted with, well, we're waiving immunity to these specific claims that are viable now, and these types of tort claims for economic loss are just not within the landscape of the law confronted by the legislature when it enacted 768. And again, Your Honors, it's not within the letter of the law either, which has to be construed narrowly, we know, because it's an derogation of the common law. I know I've exceeded my time, and I appreciate the panel's pleasure.
If we assume, for the sake of argument, that the doctrine of sovereign immunity bars the appellee's claims, what remedies are available to the appellee?
Your Honor, there was I think it's Wallace v. Dean that made this point, and it's certainly in the Jackson case, the fourth Supreme Court case, finding that there's immunity to claims doesn't mean that the action is, I guess, not tortious. It just means that the state is immune from it. There's reasons that the state has an immunity. The public policy reasons that this court is well aware of, the prevention of encroachments into the public treasury, the ability for state agencies and local governments to be able to do their job without interference and being hauled into court for all of their decision makings, and when a citizen disagrees with their decision makings. And of course, the separation of powers doctrine, which prevents courts from involving themselves in the exactions of the other branch. So I think that if there were an ongoing issue with charges which hasn't been alleged, that there could be potentially a declaratory judgment action in that case for declaratory relief or injunctive relief. But in this case, the operation of the immunity just means that the state is immune for it. And As to remedies, I don't know any other way to answer that question, Your Honor, but the state of Florida enjoys that immunity by virtue of the Constitution, enjoys that immunity by virtue of the separation of powers doctrine and the express provision of the Constitution concerning immunity, and these claims, which really are just implied contract claims, calling them for what they are clearly not within the 768 waiver enacted by the legislature. And I'll conclude on that. I appreciate the panel's pleasure again in letting me go over a little bit. Thank you.
Thank you, counsel.
May it please the court. Robert Peck on behalf of the appellees. I'd like to start with the fact that when the legislature enacted 1009.24, they made all the policy decisions that are at issue in this case. They made a determination of the maximum that could be charged, and they obligated the university and the board to comply with that. There was no discretion that they could otherwise exercise. When they chose to use an outside vendor, that was within their discretion, but they could not pass along their extra costs no more than they could if, for example, they hired extra staff to process those applications.
Counsel, who made that decision? Who made the decision to hire the outside vendor? Who made the decision to set the processing fees and the extra charges for preview?
We're here on a motion to dismiss that was denied.
Sure, but you
so
opened with the education.
Well, what I said is that they're free, both the university and the board, to make that decision, which I presume they did, but they're not free to charge more for that.
When you say they, who are you talking about?
The board and the university.
So you're saying the board and the university, your allegations are that the board and the university, the board of trustees and the board of governors, they decided to set these charges?
Well, under law, that's the board is responsible for doing so.
Are you saying that you don't know yet who actually?
What?
Are you saying that at the pleading stage you still don't know who actually set those charges?
Precisely how it operated, we don't know, but what we do know is that the university conveyed these charges. We know that the board approved it. We know the board is aware of exactly what charges are done. They are obligated by law not only to set the fees, but also, and they're specifically prohibited by this statute from setting the fees for applications and for orientation above the statutory limits. And we also know that they're obligated to collect those fees, the board is. They're obligated to put them either into separate checking accounts, or if not into separate checking accounts, they're obligated to keep the books so that they can keep track of that. After all, they claim the extra $5 was then kept for purposes of paying the vendor. They claim that they conceded at the trial court that the orientation program is a self-funding program, so the money is segregated for purposes of that. So
isn't there a remedy then against the board of trustees or the board of governors through administrative proceedings, like to challenge? I mean, if this is being set by the board of trustees or the board of governors, why not go and go by a rule proceeding?
There is no administrative remedy. Plus, the fact of the matter is that this perfectly fits the torts of conversion and negligent misrepresentation.
Well, what about going to the main argument here about waiver of sovereign immunity? How is it that economic damages or economic loss is covered under the waiver under 768.28 subsection 1?
First of all, of course, the Florida Supreme Court in the Tierra case limited economic loss to products liability cases.
No, it limited
it returned it to its common law roots. What?
It limited the application of the rule to product liability.
That's right. And
but that doesn't change the categorization that is historical and goes back way past the 2000s and 1990s. The distinction between bodily injury property damage, economic loss, expectation damages, contract damages. I mean, those are all categories of damages.
Your Honor, I think that what we have to look at, the waiver of sovereign immunity is modeled after the Federal Tort Claims Act. Federal Tort Claims Act certainly recognizes that money is damages that can be collected under the Tort Claims Act.
Is the FTCA exactly the same as 76828 subsection
Not
1?
exactly the same, but they're modeled, and the key point is the legislature said that if a tort, a private party could be liable in tort, then the state would be as well. That's the decision that they made. It applies. It doesn't mean that when the Florida Supreme Court changes the economic loss rule to its original roots, that the legislature has to act again. They've made a plenary decision about torts and how they apply. If they want to vary from that, they need to enact something new, but they have not done so in nearly a decade since that decision.
Well, that focuses on just one phrase in a very long sentence in subsection 1. What about the part, though, that says to recover damages in tort for money damages against the state or agencies for injury or loss of property, personal injury, or death?
So we're talking about what the definition of loss of property is. And the defendants have conceded that money that has been converted can be a loss of property. They said so in their brief. The Belford case on which they rely also says so. And so the question then becomes, is it identifiable money? We know it doesn't need to be earmarked, but as I just described, it is identifiable money because it is specifically earmarked either for a vendor, so it's converted for use for expenses that the university has incurred that they would not otherwise that they would otherwise have to pay for if they weren't essentially taxing the students for it. And
do you then concede, though, that that phrase that I just, I guess the prepositional phrase that I just read to you, for injury or loss of property, personal injury or death, that is the limitation on the sovereign immunity waiver?
it is, and I say that we
question?
qualify it as a loss of property. If I get money taken from me because the state thinks that it is owed that money but doesn't owe it, that's a loss of my property. The loss of that money can be the state. We've seen conversion claims going to investment accounts. We've seen it going to bank accounts. And so there's no difference here. And certainly, as I said, under the Federal Tort Claims Act and as other instances where conversion has involved money, this court has not found any problem, nor has any of the courts in Florida, when that is requested back as a conversion claim. Remember, the conversion derives from trover. It's not replevin, which is the return of the exact same item. It derives from trover, where you're due compensation for what has been taken, which somewhat mirrors the takings clause and the need for fair compensation.
But doesn't trover typically also involve chattel? Or
It can also mean money. We have many cases in which, the United States has sued over $600,000 something dollars and things like that. What?
And what about in Florida?
And in Florida, what we've said is, as we've said, Florida, we found that when a bank account has been wrongly taken, we have found that conversion is possible. There's a case in which
Well, I'm asking about trover.
What?
You mentioned trover. So in Florida, historically, trover, has it involved things besides chattel?
I'm not aware of trover involving things besides chattel, but as I said, we have considered money to be property, and the defendants have conceded that that's the case.
Counsel, you referred earlier to 768.281. Okay, 768.21 waives sovereign immunity under circumstances in which the state or such agency or subdivision, if a private person, will be liable to the claimant. Will a private person be liable to the claimant for a conversion claim?
I'm sorry, I'm not hearing you.
Let me repeat the provision again for you. Waiving sovereign immunity under circumstances in which the state or such agency or subdivision, if a private person will be liable to the claimant.
That's right.
Okay. Would a private person be liable to the claimant for a conversion claim?
Yes.
Would a private person be liable to the claimant for a negligent misrepresentation claim?
Yes.
Okay. Now, you may have addressed this issue earlier, the question concerning the conversion claim. In this case, doesn't the case law on conversion require an obligation to keep intact or deliver the specific money in question?
I'm sorry. I'm
A
having
case law on conversion, that is the case law on conversion, doesn't it require an obligation to keep intact or deliver the specific money in question?
It doesn't require that the money itself be kept intact as much as it be identifiable and separate. And so,
And how is that requirement met in this case?
And
Or alleged
that
in this
requirement is met because the board itself is obligated to collect the fees. If I can,
This is a plea requirement. It is alleged in your amended complaint.
yes, it
this
is.
requirement.
It is alleged in the complaint, and Section 1011.42 of Florida statutes obligates the board to maintain meticulous records of all funds received by a university from whatever source and for whatever purpose, showing the amount subject to withdrawal, the amount deposited, the amount expended, and the balance of the account. It further states the university may maintain a separate checking account for each fund, or it may utilize a single checking account but segregate the various funds on the books and records. That's what we have alleged has occurred here. And if I can go to the point that my friend made about Morelli and Pembroke Pines. Morelli, of course, precedes the Tierra condominiums case, and so therefore it applies an economic loss rule that does not currently hold sway in Florida. And oddly enough, when Pembroke Pines endorses the rationale in Morelli, it quotes this part, that fraud in the inducement causing only economic loss does not fit a category of personal injury, wrongful death, and injury or loss to property. We've shown that conversion and negligent misrepresentation do. They further say that, moreover, fraud in the inducement is a tort independent of breach of contract, as if that were a problem with it. But we know from Justice Perienti's concurrence in Tierra condominiums that the independent tort doctrine still applies and actually authorizes the bringing of the tort action. Here, this is plainly an independent tort. We're not seeking a breach of contract. There is no question about what the contract said and was not complied with. What we're doing is something that's outside of the contract because the statute itself obligates the board to collect and charge and inform students of no more than the set statutory fees. When they violate that, they are operating outside of the contract. They are converting funds that are paid into them that they are holding dominion over when someone else has a legitimate claim to them. That's the essence of conversion. And they have misrepresented.
Just going back to your conversion claims.
Yes.
Isn't appellant's alleged obligation to refund the overcharged fees a mere indebtedness that can be discharged by the payment of money generally, rendering it an improper subject of conversion pursuant to the applicable case law?
Yes. So what we have here is, of course, a request that's been made for that money to be paid back. They have resisted it. They continue to defend that they have a right to it, which is the reason why there's a declaratory judgment count to all this. The declaratory judgment count is not covered by sovereign immunity. Sovereign immunity exists to protect from interference with government functions and to prevent raids on the public fisc. Declaratory judgments are anticipatory justice. And so what we're trying to do is get a declaration of rights that our clients did not have any obligation to do so. Students in the future do not have any obligation to pay those excess fees, and therefore—
And then what will you do with that judgment? What would you do with that declaration?
And that judgment then informs our conversion and negligent misrepresentation claims, which do go to damages for a violation of rights that have been established by statute.
So you're using the declaratory judgment counts to circumvent the elements of the tort counts, and
no.
then you want to come back around
No,
and...
we're approving the counts that deal with conversion and negligent misrepresentation, but we also want to show that the university and the board do not have the right to go back and continue to do this kind of a charge in the future, which they are adamantly defending that they had a right to do now.
Do you have any plaintiffs that are anticipating or planning on going to University of Florida that hasn't gone yet, and they want to know in advance?
Some of the
whether-
applicants who are part of the application class were not accepted and are and could reapply.
And is that alleged in your complaint, that we have at least one member of the class that is in doubt as to whether they have to pay their fee?
No, we have not, but we have
Okay,
not.
so then your declaratory judgment counts have nothing to do with future
Except, of course, we are here on a motion to dismiss, and there will be an opportunity to amend that if we needed to.
For a fourth time,
Yes.
or fifth time, actually.
So, if I can continue, so Springer in the
Counsel,
Third Circuit.
Let me digress for a second again. You answered my question in terms of the Declaratory Judgment Act, but my question went directly to your conversion claims for damages.
Right.
Can you address the question in terms of
Yes.
your
So,
conversion claims?
first of all, in the Third Circuit, we cited the Springer case, and from the Fifth DCA, we cited the Strickland construction case. Those are two cases in which conversion cases have been allowed to proceed against state agencies. The intent issue that has been raised by the defendants is really something of a canard. It seems to conflate mens rea with the civil kind of intent. Certainly these charges weren't made inadvertently, they were made intentionally. They were made intentionally under a mistaken belief that they had an entitlement to do so. We think the statute makes it very clear that they do not. And so, of course, when you overcharge someone like this, it is a conversion because you're exercising dominion over that excess property that you took from the plaintiffs when they have a legitimate claim to it, which is the essence of conversion. Now, as I said, the appellants do not disagree that money can be property.
Counsel, yeah, and on that, I mean, regardless of whether counsel concedes or not, we ultimately have to make the decision as to what the statute means. And I still don't understand the argument when looking at 768-28, how you're equating loss of property, injury or loss of property, with money, or including money in that category, given historically how that phrase has been used at the common law, talking about traditional negligence, which my understanding historically, at least in Florida, is that the purpose of it is to protect person and property from physical injury. And I having a hard time understanding how money can be injured, considering it's just a means of exchange.
Let me see if I can help you here. And that is because under English law, dealing with this kind of conversion, if someone found a bag of money belonging to someone else and thinking that it was finders keepers, it was property that they could take, the issue would then be about that bag of money, and it would be considered conversion. And if you could prove that you rightfully owned it, that you hadn't abandoned it, you would get to claim it back. That's in a private cause of action.
I'm not disputing that there's a tort in Florida for conversion.
And I'm saying
that may even cover that, just the same as there are torts that cover
right.
breaches of contract
but
and
that
negligent
is
misrepresentation.
a dispute of conversion over money.
Right, but
And
what I
this is-
want to know is how is it, as used in 768-28 subsection 1, the loss or injury of property, as used in that statute, how you think the legislature had in mind chattel and the traditional torts, and then anything else that might be subsumed under economic damages.
I think that what Judge Lewis pointed out, that the state is liable in tort to the same extent that a private person is how the legislature viewed the question of what property would be. So this was a waiver of sovereign immunity in tort.
For all torts, basically?
For all torts, except to the extent that they accepted it out. For example, willful and malicious torts are not something that the state would be waiving any liability for, because that would be the person who did that would be acting outside the scope of their employment, and therefore they would be personally liable. The statute makes that very clear.
If that's the case, then what is the purpose of having that phrase in at all? I mean, why even have a mention of injury or loss of property, personal injury or death, if it's just going to include all torts?
Well, because those are the typical injuries that occur in tort. And I think that that's all the legislature was doing, was trying to mirror what tort law was.
But they could have done that if you just took your argument, and they could have done that just by saying liable to the extent that a private person is.
But of course, as I said, and precedent confirms, they copied much from the Federal Tort Claims Act, and that phrase appears in Federal Tort Claims Act as well. So I think that this was simply cribbing and thinking that this covers tort. There's no indication whatsoever, either textually or through legislative intent, that the legislature was not thinking in terms of all those torts. So I see my time is up. What I'd like to conclude with is the fact that these are torts for which the state has waived its sovereign immunity, that there's no discretionary act here, that to the extent that my friends rely on Maselli and Pembroke Pines, those are hard to justify as being compliant with the Florida Supreme Court's decision in Tierra Condominiums, which of course is the only mandatory precedent that we're discussing here, that money can be the loss of property, and for that reason, the judgment below should be affirmed.
Thank you, counsel, for your respective oral arguments this morning. This concludes our oral arguments for this morning. We stand adjourned.